Why Nigeria Can't Try Me by Nnamdi KANU. The leader of the indigenous people of Biafra, IPOB, Nnamdi KANU, has urged the Federal High Court to decline jurisdiction to adjudicate on the charge of treasonable felony filed against him by the federal government. Yes, the federal government of Nigeria have not been able to even stay in the court to fortify the charge against Nnamdi KANU. They are the ones adjourning cases, and it is not speaking well of the reputation of the so-called federal government of Nigeria. Is it Nnamdi KANU who is a problem of Nigeria, or Sunday Igboho in the other end? That is why Nnamdi KANU is saying Nigeria can't even try him because they have failed on arrival. KANU, who maintained that he was not guilty to the 7-count charges, stated that from the amended charge, the only element required to constitute and found liability for incitement allegedly occurred wholly and entirely in London, United Kingdom, and not anywhere close to Nigeria. In his preliminary objections, KANU urged that the alleged broadcasts were not shown to have occurred at the sea or on the international waters above Nigeria, adding that I know as a fact that London, the United Kingdom, is a sovereign state under international municipal law and has municipal laws punishing criminal offenses. The preliminary objections filed by counsel to KANU, Barrister Ifeanyi Ejiofor, further stated that I also know as a fact that the jurisdiction is extrinsic to adjudication. It is conferred on the court alone. It is not intrinsic, that is coming from Ifeanyi Ejiofor, the lawyer. He says that I know as a matter of fact that as the elements necessary to constitute incitement in the alleged several brokers or the defendants applicants occurred in London, United Kingdom, and not in Nigeria. The court in Nigeria has no jurisdiction to try the defendant applicant on any charge founded on any such alleged incitement, even if the defendant applicant enters within the geographical boundaries of Nigeria. The affidavit in support of the objection deposed by Chinwe Umeche averred that the alleged offenses for which the defendant was charged do not constitute terrorism offenses in London, the United Kingdom, where they were allegedly committed. I am further aware that there is an obligation on the Attorney General of the Federation to maintain international cooperation for compliance with international treaties on terrorism. The defendant was abducted from Kenya and consequently extraordinarily rendered to Nigeria without firstly subjecting him to extradition proceedings in Kenya. This is a violation of all known international conventions and treaties on extradition. Prosecuting the defendant on the 7th-count charge would amount to allowing the complainants to benefit from their illegality and wrongdoing. I am aware that he who comes to equity must come with clean hands, and no party should be allowed to benefit from his wrongdoings. I know as a matter of fact that the extraordinary rendition of the defendant robs the Honorable Court of the requisite jurisdiction of trying to defend on count 4, 5, 6, and 7 on count 3 of the charge relates to an offense allegedly committed in Hubulu Sizo in Hiala, local government area of Anambra State, which is outside the territorial jurisdiction of the court. An offense can only be tried by a court exercising jurisdiction over the place or area where the alleged offense was committed. Count 5, 6, and 7 of the charge did not disclose an offense known to law. There is no proof of any evidence attached to the charge filed against the defendant. Even the purported proof of evidence to be relied upon by the prosecution does not disclose any prima facie case against the defendant. From the list of exhibits and witnesses attached to the charge, there is nothing relating to or linking defendant to the 7-count charge, particularly counts 4, 5, 6, and 7 thereof. No final pronouncement has been made on the purported proscription of the indigenous people of Biafra, as the said purported proscription is a subject matter of appeal in appeal number CAA 214/2018, pending before the Abuja division of the Court of Appeal. A defendant applicant cannot be arraigned anew or tried for an offense when the judgment that made a pronouncement on the instrument constituting a state of affairs as such an offense is the subject matter of an appeal. It will be most unjust, painful, wicked, and unfair for the applicant to undergo the rigors of a full trial when the charge as constituted does not disclose a prima facie case against him. There is no ground for this court to proceed with the trial against the applicant in the circumstance of this case. The court has the powers and a duty to stop a prosecution which on the facts creates abuse and injustice. It will be in the best interest of justice if the present 7-count charge is struck out and or dismissed. Kanu in addition asks the following questions for determination: whether the court has the requisite jurisdiction to try the defendant on the 7th count charge in view of the extraordinary rendition of the said defendant applicant; whether the court has the jurisdiction to try the defendant applicant for alleged act constituted wholly by element that occurred within the geographical space of a foreign sovereign nation and outside the jurisdiction of the court; whether the defendant applicant can be prosecuted for allegedly belonging to a proscribed organization when the purported proscription of the organization is the subject of appeal in appeal number CA, which I've read pending at the Court of Appeal, Abuja Division, thereabout. Well, whether the information as laid under counts 1, 2, and 3 of the amended charge is not founded under a non-existent law; whether the radio broadcast alleged made by the defendant applicant constitute an offense of reasonable, treasonable felony as envisaged under section 41. Yes, all these are being the charges leveled against Nnamdi KANU, but as it is, the court could not even present all these documents as a proof of what the evidence in support of the 7th count charge discloses a prima facie case against KANU. Well, KANU therefore argued that his extraordinary extradition from Kenya to Nigeria robs the court of the requisite jurisdiction to try him. We respectfully urge your lordship to decline jurisdiction to entertain the instant charges, as the alleged offenses contained therein were allegedly committed wholly in the London, United Kingdom, and Anambra State outside the territorial jurisdiction of this court. The court is further urged to strike out or dismiss the count of the charge which are incompetent and brought pursuant to unknown provisions of the laws. We further urge this court to hold that the purported proof of evidence to be relied upon by did not disclose any prima facie case against the defendant, that we invoke the power of this court to set down the case for trial. The 7th count charge filed by the prosecution, we respectfully submit, is not only as naked as empty as a worthless paper, but not founded on existing laws, and the court is respectfully urged to, upon a meritorious consideration of the grounds upon which the objection is predicated and arguments in support therefor, to dismiss in its entirety the 7th count charge and accordingly discharge and acquit the defendant applicant on those charges. Yes, you have listened. So Nnamdi KANU definitely and his lawyer, they have spoken well. To summarize, he says, if you are in that somebody, you are pointing accusing finger at somebody, you should come clean definitely, and the jurisdiction whereby the offenses were being carried out should be where the court case should go.